thought the hesitation of the officers that you pointed out before showed care before rushing in and thoughtfulness by the officers. So why don't you look at it that way?
Your Honor, I think that the delay, there were deliberations that were quite extensive, and it took them 40 minutes to go in, as the dissent in the decision below noted. That amount of time is inconsistent with the kind of urgency you would expect if what you thought was happening was somebody was either bleeding out or was about.
Well, if they, after deliberations, walk away and he commits suicide, I mean, what are you thinking then of the officers?
That would be unfortunate and tragic, but we are trying to strike a balance between.
Well, and the officers need some clarity, I would think, in circumstances like this about what they can do and what they can't do, and it seems like they thought about it carefully and decided that the risk was sufficiently high, to Justice Jackson's point, and that harm that would occur was sufficiently substantial that they should go in. And by the way, they're going in at great risk themselves.
Of course,
and you know, this is not, as Justice Gorsuch is pretextually looking for a crime or going in for some other pretextual reason or going into, you know, it's going in really to help someone.
A couple of responses. One, there were certainly two risks that were possible. There was the risk that he was going to shoot himself, and there was the risk that he would try to provoke a confrontation with the officers. J.H., the ex-girlfriend, actually identifies both risks. In the initial call, she expresses concern that Mr. Case is going to shoot himself. When she arrives on the scene, because she comes to the scene, she says that he also said that he was going to try to shoot it out with the officers, and that echoes what Officer Lindstedt says when he arrives on the scene. What he says shortly after arriving is, last time we were here, he said he was going to shoot it out with, and then he mentions another officer and I, and then later on he recounts another incident where Mr. Case tried to provoke a confrontation.
I'm sorry,
on his perception.
Sorry about that. On the articulation of the standard you want, do you have examples where under the current law officers would go in, but you think under your test they wouldn't and shouldn't and couldn't go in?
Well, Your Honor, I think the swatting example that we cite in our brief is a very real concern. It's a pretty commonplace concern where somebody calls, and under the United States theory, I think it's at page 22, where you would use the severity of the threat to ratchet down the level of certainty that's required. If somebody made a swatting call and said, well, there's a bomb inside the house, it's a pretty big bomb, I walked by the house and I'm worried that it's going to blow up the block, you wouldn't even need corroboration. You could just go in. And so we think that just requiring a fair probability or a substantial chance and some corroborative work, and I think in a lot of heartland scenarios, the police would have that and would